Okay, we're live.
Okay, thank you, Pratyush. Very good morning to all our listeners. This is Anekdhara's 30th edition in its webinar series. And each time we have been very fortunate to have brilliant minds speak to us on very interesting topics of their area of expertise. Today, we are indeed very fortunate to have Mr. Raju Ramachandran to speak to us on a topic which is probably the best way to celebrate the 75th anniversary of our republic, on role of governor. And so I will ask Vikram, who is an advocate in Delhi and is in his last final stages of his doctorate program, I'm told, at Humboldt University. He will be moderating and in conversation with Mr. Ramachandran. So I would ask you, Vikram, to both introduce our distinguished speaker and talk about the relevance of today's topic. Interesting. So over to you, Vikram.
Thank you. I'll begin by introducing Mr. Ramachandran. He is a senior advocate at the Supreme Court of India and has been a senior advocate since 1996, if I remember correctly. He was Additional Solicitor General of India between 2002 and 2004. And he has been appearing in many landmark cases over the last few decades. If I started listing those, that'll take very long. So I'll just say that anyone who wants to see which those matters are or what kind of work he has been an expert in, one can Google his name and go through those cases. With that, I'll move on and begin with the session and just talk a little bit about the topic. So I had the chance to discuss with Mr. Ramachandran how this webinar would proceed, and deviating slightly from the ordinary role of a moderator, I will be speaking for a couple of minutes just to give a brief historical background as well as explaining the position of the governor under the constitutional provisions, after which Mr. Ramachandran will give his lecture and talk to us about his perspective on what is the utility of having that office under the Indian Constitution. Sir, would you like to say anything at this point? You raised your...
You complete your note.
Okay. So I'll begin quickly with the history of the office of governor. In 1858, the Government of India Act transferred power from the East India Company to the British Crown, and it was then that the governor became an agent of the Crown, supervised by the Governor General. Later, in 1919, reforms introduced the idea of responsible government, but the governor remained key to provincial administration, and vast discretionary powers were vested in that office. Now, in 1935, provincial autonomy was brought in, requiring governors to act on ministers' advice. However, governors still had special responsibilities like maintaining peace and protecting minorities. They could also act independently in certain matters. In 1937, when the Government of India Act 1935 came into force, the Congress Party commanded a majority in 6 provincial legislatures. They foresaw certain difficulties in functioning under the new system, which expected ministers to accept if the governor exercised his individual judgment for the discharge of his special responsibilities. The Congress Party agreed to assume office in these provinces only after it received an assurance from the Viceroy that the governors would not provoke a conflict with the elected government. Until the Constitution took effect, the Government of India Act 1935 applied. This was adapted by the India Provisional Constitution Order of 1947. And this constitution order removed phrases like "in his discretion," therefore making it mandatory for governors to only act on the advice of the Council of Ministers. This is a brief background of the position that governors, of the role that governors played before independence. Now, very briefly, I'll just be talking about the Constituent Assembly debates to discuss how India arrived at the position of having nominated rather than elected governors. And then I'll hand over to Mr. Ramachandran. The dissatisfaction with the experience of nominated governors in the pre-independence era appeared to strengthen the argument in favor of stipulating that governors would be elected under the Indian Constitution. Accordingly, the constitutional advisor, Mr. B.N. Rao, framed the first draft of the Constitution, stating the governor shall be elected by direct vote of all persons who have the right to vote at a general election for the Legislative Assembly of the province. While the draft was before the drafting committee, which comprised 7 members, including Dr. B.R. Ambedkar and Sir Alladi Krishnaswamy Iyer, the drafting committee took a different view on the mode of selection of governors, suggesting that the selection should be done by the president from a panel of 4 members elected by members of the state legislative assembly. In a note prepared by Dr. Ambedkar to explain the revisions made by the drafting committee, he stated, some members of the committee feel that the coexistence of a governor elected by the people and a chief minister responsible to the legislature might lead to friction. Accordingly, the drafting committee's solution was that the governor of a state shall be appointed by the president. When the draft was finally debated in the Constituent Assembly, this modification led to heated arguments, both supporting and opposing it. Mr. Brajeshwar Prasad, who was elected from Gaya on a Congress ticket, moved an amendment to the draft provision as formulated by the drafting committee and led the arguments in favor of the president having an open hand in nominating governors rather than being restricted to a panel compiled by members of the state legislative assembly. He argued that it was necessary that the authority of the central government be maintained over the states and that the constitution should encourage centripetal tendencies. Prasad argued that the president should have a completely free hand in nominating governors of the states, and further argued that the governor should not belong to the state where they would be appointed, as that might encourage fissiparous tendencies. Among those who supported Prasad's argument were Jawaharlal Nehru and Sir Alladi Krishnaswamy Iyer. Nehru expressed his concern that having elected governors in the states would encourage separatist sentiments that no doubt existed in pockets of the nation that was being put together even as the constitution was being debated. Sir Alladi Krishnaswamy Iyer argued that the wisest course would be to have nominated rather than elected governors, pointing out that governors nominated by the president could play a crucial role in ensuring that harmony is secured between the center and the states. It is worth noting that Alladi Iyer also argued that the selection of governors could be carefully done by the president, whereby the president acted on the advice of the prime minister and his cabinet, and by building a constitutional convention wherein the president would consult the provincial cabinet as well. That's all I'll be saying about the Constituent Assembly debates. Now I'll provide a brief overview of the provisions of the Constitution, and then I'll be handing it over. There is one chapter of the Constitution that is specifically focused on the power of the governors, and that is from Articles 153 to 162. I will just quickly mention what these provisions cover before then moving on to other provisions which are not in this chapter. Article 153 simply clarifies that there shall be a governor for each state. Article 154 provides that the executive power of the state shall be vested in the office of governor. Article 155 stipulates that the governor shall be appointed by the president. 156 clarifies that the governor shall hold office during the pleasure of the president, while clause 3 of this provision states that there would be an outer limit of 5 years for this term. Article 157 lays down 2 eligibility criteria for persons to be appointed as governors. 1, they must be citizens of India. 2, they must be over 35 years of age. Article 158 provides for certain conditions for a person to be governor, including that they should not be a member of parliament or state legislative assembly, or of any state specified in the first schedule. And second, that they should not hold any other office of profit. Article 159 specifies the oath to be taken by the governor, which requires them to affirm that they would, to the best of their ability, preserve, protect, and defend the Constitution and the law, and would devote themselves to the service and well-being of the people of the state that they are made a governor of. Article 159 also mentions that this oath will be taken in the presence of the Chief Justice of the High Court, exercising jurisdiction over that state. Article 160 empowers the president to stipulate how governors are to exercise their powers in contingencies not covered in this chapter. Article 161 specifies the power of governors to grant pardons, to suspend, remit, or commute sentences in certain cases. The final provision in this chapter, Article 162, states that the executive power of the state shall extend to matters with respect to which the legislature of the state has power to make laws, and is followed by a proviso clarifying that this power can be expressly limited by the president or parliament with respect to matters that both parliament and the state legislative assembly have the power to legislate on. Now, of the other provisions of the Constitution that are very significant with respect to the office of the governor are Articles 163, 174, 192, and 200, 213, and 356. Now, of these, Mr. Ramachandran will be going into great detail while discussing Articles 200 and 356. So I won't be mentioning anything more about those. And I think since it's already now been 10 minutes, I'll just hand over to Mr. Ramachandran to begin his address on the role of the governor.
Thank you, Vikram, for your very kind introduction of the speaker and for your comprehensive introduction to the constitutional concept of the governor, and for sparing me the dirty work of referring to the various provisions of the Constitution. But first of all, happy Republic Day, everyone. Long live the Republic. And happy Republic Day from Chennai. And why I'm mentioning my camp location just now, though it might otherwise be of little interest to anyone, is that Chennai is the home of two eminent members, at least two eminent members of the Constituent Assembly, Shri Sir Alladi Krishnaswamy Iyer and Shri T.T. Krishnamachari. And in the constitutional context, today, it is important to mention that Chennai is the Karma Bhumi of Governor R.N. Ravi. This is of special significance on a day like this, especially because I see from today's newspaper that Governor R.N. Ravi is again in the news. In his customary Republic Day message given on the eve of Republic Day, that is yesterday, he has cautioned the people of Tamil Nadu against fissiparous tendencies, which has brought a spirited rejoinder from a minister of the Tamil Nadu government that he is implying that there are secessionist tendencies in Tamil Nadu. And he berates Tamil Nadu, which is one of the most advanced states of the country, for being lax on various fronts like education, healthcare, etc. So, Governor Ravi symbolizes today the malaise which affects the institution of the governor, and he typifies the kind of person who induces people to say, why must we have a governor at all? And so, in my talk today, I'll be stressing on the importance of the role of the governor in the Constitution and what can be the safeguards against abuse of the office and abuse of powers by the governor. Now, the Indian Constitution is a federation, but a federation with a strong unitary bias. It is not a classic federation in that sense because of the unitary bias. It was so created after detailed and conscious deliberation by the Constituent Assembly, because the need for centripetal tendencies was emphasized in the debates. as Vikram pointed out, one of the issues which was debated was whether we should have elected governors. And this was negatived on the ground that it would lead to two parallel centers of power and therefore to great friction between a governor and a chief minister. There is an additional reason, I submit, why this idea of an elected governor was not a good idea in the first place. In the very nature of the structure of the federation, the governor of a state has to be an outsider. If you had an elected governor by popular vote of the population of a particular state, in the very nature of things, he'd have to be a person from that state. And the purpose is lost because the concerns and passions which weigh upon the population of a particular state would be concerns and biases and prejudices which would weigh in the mind of the governor also. And therefore, you need someone detached from local politics to be a governor. But then, is the governor, in the role assigned to him, a sage or a saboteur? This I'm plagiarizing from the title of a book on governors edited by my late mentor and Attorney General Solicitor. Serious essays on the role of governor, both by people from the political class and from distinguished bureaucrats like Narayan, who distinguished themselves in their roles, who understood their constitutional role correctly. We'll come to the sage or saboteur bit a little later again. But let's now talk about major reasons why the Constitution as it stands, the model which we have chosen for ourselves, requires a governor, how the governor plays a very important and pivotal role in the scheme of things. One, Article 356, President's Rule. This assigns the governor with the task of reporting to the president if he or she finds that the government of the state cannot be carried on in accordance with the provisions of the Constitution. There have been so many instances in the past where president's rule has had to be imposed, sometimes for very justifiable reasons, but often not for justifiable reasons. And so the importance of the role of the governor, the personality of the governor, the wisdom of the governor, the statesmanship of the governor are all involved. And let's remember that it's not just a recent phenomenon, this abuse of the role of the governor. Let's remember that it was under the Congress government in 1958, when Jawaharlal Nehru was the Prime Minister, Indira Gandhi went to Kerala, just decided that all that the communists there were doing was wrong, and persuaded her father that the constitutional mechanism had failed. That was the first instance of abuse of the power of governor. Then we had the instance of a particularly rogue governor called Ramlal, a former chief minister of Himachal Pradesh, his role in Andhra Pradesh in the context of N.T. Ramarao and the politics of the Telugu Desam in the 80s. But a wise governor would, first of all, caution the state government. And when caution fails, then make his or her report. So since this is a federation with a unitary bias, the role of the governor in the context of Article 356 is essential, but it has to be exercised with a great sense of responsibility. The second area where the role of the governor becomes important is in the context of swearing in a popular government, where the role of the governor is akin to the role of the President of India or the Queen or the King of England. When there is a clear majority, there is no problem at all. But when there isn't one, what are the constitutional conventions to be applied? Do you invite the largest single party, give it a chance to form a government? Do you invite the largest pre-poll coalition, if that is what wins a majority? Or do you invite a post-poll coalition in the event of a hung assembly, because then majorities are cobbled together only by post-poll coalitions? These are all tasks which the governor has to undertake using constitutional conventions and his own wisdom, and then to order a floor test in situations where a claim is staked which appears tenable on the face of it, but needs to be actually demonstrated on the floor of the House. So this is again one of the contexts in which the role of the governor is very important in our constitutional scheme. And the governor has precedents to guide him or her. Let's go back to the time when R. Venkatraman, a statesman politician, was the President of India. He had been a distinguished lawyer, a distinguished politician, handling important portfolios with great distinction. He was a textbook president, a copybook president, and he issued presidential communiques explaining why he exercised a particular choice. So you need governors in the states who are conversant with constitutional conventions to make the right decision on whom to invite to form a government. The third constitutionally important situation and context is in the context of the legislative lists which our constitution has made provision for. The union list, the state list, and the concurrent list. Now, every act of the state government, every act passed by a state legislature needs the assent of the governor. But the Constitution envisages situations where the governor reserves for his consideration, sends back a law for reconsideration. The Constitution then provides that if the state passes the law again, in spite of sending it back, then the governor has no choice but to give his assent. But there are situations where the governor reserves it and sends it to the president for consideration. And these are well thought out constitutional provisions, because in the matter of legislative lists, there is much scope for bona fide dispute on whether a particular matter is clearly within the remit of a state legislature, or does it legitimately belong in the realm of the union parliament. And every situation is not black and white in the context of these different legislative lists. There is great scope for overlap. And so our courts, our constitutional courts over the years have applied something called the doctrine of pith and substance to see whether the nature of a particular law, is it in pith and substance something which pertains to the legitimate powers of the state, or does it encroach upon the powers of parliament? Then there are other constitutional doctrines like the doctrine of the occupied field when it comes to the concurrent list, that this field is already occupied by a central legislation. So therefore, many state laws passed bona fide by the state assembly, legitimately believing that they are within the powers of the state legislature, can still have constitutional problems, and there can be legitimate, understandable situations where a governor therefore reserves assent, sends it to the president. But again, this role requires great wisdom, knowledge, experience, and statesmanship on the part of the governor. Now, at the time of the Constituent Assembly debates, which Vikram referred to, there was a fond hope expressed that conventions would evolve by which the chief minister of the state would also be in the loop. He or she would also be consulted in the appointment of a governor. But sadly, those conventions have not been built up and the chief minister of the state is invariably bypassed, and governors are expressly chosen for their potential to create friction, unfortunately. One is, of course, governors are chosen because retired politicians need to be pensioned off suitably, need to be found sinecures, like some favored bureaucrats need to be given sinecures. But they will always, of course, enjoy the confidence of the central government, and the governor holds office at the pleasure of the president. He or she can be sacked. The president can only be impeached, but the governor holds office at the pleasure of the president. So one is, of course, rewards for loyalty. But the other consideration which weighs is whether they have the potential to use a colloquial expression, if I may, in this solemn webinar also, they are chosen for their panga-taking abilities. And many of today's governors and many of yesterday's governors under both the Congress regimes and the BJP regimes have shown great potential and fulfilled their potential as panga takers. But it is not always so. I'll give you two recent examples. Now, it was the Biju Janata Dal which dislodged the Congress from power some years ago, of course, after which Naveen Patnaik enjoyed a long tenure. But the governor of Orissa, the late Murli Bhandare, a long-standing congressman, had the most cordial relationship with Chief Minister Naveen Patnaik. Similarly, President R.N. Kovind, in his previous avatar as governor of Bihar, had a cordial relationship with Chief Minister Nitish Kumar, even at the time when Nitish Kumar had first tied up with the RJD, ditching the BJP. But when R.N. Kovind was nominated for President of India, Nitish Kumar, who was then an opposition chief minister, complimented R.N. Kovind for his constitutionally correct role. And I'm remembering a former chief justice, though I personally believe that former judges and chief justices should not accept the office of governor, because having held high constitutional posts where they could have only been impeached, they are now holding office at the pleasure of the president. I think that is a demotion, but well, many have. But one particular judge, Chief Justice Rama Joyce, former Chief Justice of the Punjab and Haryana High Court, he's a judge from Karnataka, a lifelong RSSite, someone who went to jail during the emergency. In his judicial functioning, he was impeccable. His ideological biases did not in any way impact the correctness of his judgment. And when he went as governor of Jharkhand, he said, I will be a copybook governor, and that's what he proved to be. So it is not that because a governor is of an ideologically different dispensation, therefore, he or she must necessarily or will necessarily be confrontational. But with this ever-present phenomenon of confrontational governors, being there today, we need to find a solution. This question of consultation with the Chief Minister, apart from what was expressed in the Constituent Assembly debates, was again a subject of study by the Sarkaria Commission for Center-State Relations in the early 80s and by the National Commission for reviewing the working of the Constitution set up under the Vajpayee government sometime in 2000. And both sets of recommendations again envisaged consultation with the Chief Minister of the state. But that hasn't happened. It's been 25 years now since the National Commission to review the working of the Constitution gave its report. That was chaired by former Chief Justice Venkatachalaya. So what is the solution? I am going to suggest a solution. Now, the Supreme Court, in the context of the post of Chief Election Commissioner, had suggested a collegium. The Supreme Court, though of course the law which has ultimately been passed runs foul of that Supreme Court judgment because the Chief Justice of India has been excluded from that collegium. There is a collegium for appointment of the director of the CBI. I think the time has now come for someone to move the Supreme Court, and there are bodies with established credentials. And after this webinar, I'm planning to ring up my friend Prashant Bhushan. I also plan to speak to someone in the Association of Democratic Reforms, ADR. Both are people with strong credentials to ask for setting up of a collegium where no judge is to be involved, no Chief Justice of India, no Chief Justice of the High Court, retired judge, no sitting judges, no retired judges. They have enough sinecures, they have enough arbitrations, and this is a political office. There is no need for judges to be involved. But I think it can be laid down now as a matter of law because constitutional conventions have not evolved so far. I think the Supreme Court can prescribe now a collegium which has the president, maybe the vice president or the speaker, and the chief minister of the state as members of a collegium, so that consultation is made mandatory. I end on what I hope is a constructive note. I thank you all for your patience. Happy Republic Day again. Thank you. Vikram, I hope I've stuck to time.
Yes, sir. Perfectly on time. We have got a few questions in the chat box. I'll begin with the broader question. There's one question on the Constitution itself, and the question is, should we consider a complete rewrite and reworking of the Constitution considering insights from practical experience of using it for 75 plus years? Should we consider alternative structures for how power and responsibility are organized in a digital age? Now, this moves away slightly from the topic of governor.
So out of syllabus. I'm out of syllabus, but happy to answer.
But I guess it relates to the question of at what point do we revise the structures that we have, including the office as of governor?
Yes, let me answer the first question first. Now, our constitution is a flexible constitution. And that's why this one nation, one election proposal is a subject matter of the 129th Amendment. The beauty of our constitution is that it can be amended from time to time with a reasonable requirement of a 2/3 majority, because after all, you're changing the basic law of a country. So 2/3 requirement is not a tall order. And in a certain set of cases where powers of the states are involved, by ratification with half the state legislatures, just half the state legislatures, which again is an eminently reasonable provision. So the constitution has been changing and evolving with the needs of the times, starting from the First Amendment in 1951. The only break and safeguard is the basic structure doctrine, of which again I'm making a disclosure. I need to make this disclosure in every forum in which I talk of the basic structure doctrine, because I have been a critic of the basic structure doctrine. But then wisdom has dawned upon me late and later in life, that imposes certain restrictions. So subject to that, on the basis of life experience, of course, we can change, overhaul also the constitution, but not to the extent to which it loses its identity. And all of us will agree that certain things are non-negotiable. Just because the popular will says so, can we now become a monarchy? Can the constitution be amended to say India will not be a republic, it will be a monarchy? Can the constitution be amended to say it will be a Hindu Rashtra? Though there are threats like that. Can we reinstate the caste system? Do away with Articles 14 and 16? So I think there are certain non-negotiables, and subject to that, fresh looks, revisions, and all are possible. But as far as the question with regard to digital age is concerned, I don't think the constitution is in any way an impediment and is in no way an anachronism as we move into the digital age, because the interpretative process of the constitution, as we have seen, the right to privacy has been read into Article 21 of the constitution. The constitution is wide enough, capacious enough to accommodate changing requirements. And in the Constituent Assembly, Dr. Ambedkar said, in the context of inclusion of the word socialism, though one would believe that Dr. Ambedkar himself was a socialist at heart, but he said he didn't want to put the word socialism because he didn't want to bind a future generation to a particular model of economic governance. Socialism in the sense of a welfare state is something different. A caring state is something different. But socialism as a doctrine, as a particular political ideology, he felt need not be written into the constitution, should not be. Many years later, the great Justice H.R. Khanna who gave his dissent in the ADM Jabalpur case, and about whom the New York Times wrote that a statue should be erected in the memory of H.R. Khanna, in honor of Khanna, in every city in India. What must not be forgotten is that in the basic structure doctrine also, his judgment was pivotal. It was his judgment which created a majority of 7 as against 6 to create what is called the basic structure of the Constitution. And he said something significant. While granting wide amending powers to the constituent body, subject to the basic structure, he said, no generation has a monopoly of wisdom. And so, I think our Constitution understands, recognizes, and I think our judiciary in its judicial interpretation also recognizes that the previous generation did not have a monopoly of wisdom, and therefore our Constitution is flexible enough to carry us forward for the next 75 years also.
Thank you. Now, one of these questions is, I'll move to another question on the governor, which also touches on basic structure doctrine, since that has also come up. The question is, when governors are coming out openly as agents of the ruling party at the center, and federalism, which is a part of the basic structure, is being undermined, what can be done to structurally safeguard the democratic functioning of elected provincial governments? Even with the collegium system as suggested, even though that might help, there may be situations which will require constitutional protection of elected governments' regular functioning.
One is the safeguards which have been read into Article 356, both by amendment and by judicial interpretation. That is laying the proclamation, and recommended by the Sarkaria Commission also, that no dissolution of a house can be done unless the governor's recommendation is laid on the floor of Parliament. And the second possible safeguard, and I'm thinking as I'm speaking, because this is a very thought-provoking question, and it strikes me that there can be an amendment to the Constitution providing for impeachment of a governor as well, as there is for the president, as there is for Supreme Court judges. If the governor acts so contrary to the interests of a popularly elected government, there must be scope in the written text of the Constitution for the representatives of the people of a particular state to express their disapproval. So perhaps a constitution amendment to provide for impeachment of a governor as a mode of removal and not just the pleasure of the president, because in a confrontational center, the president will never exercise pleasure to dismiss a governor who is being confrontational at the bidding of the center. And so this other method of removing a governor should also be put into the Constitution. The Supreme Court, of course, has done its bit, what it could do, by saying that it has the power to reinstate a government which has been illegitimately removed by abuse of the power under Article 356.
Thank you, sir. The next question is whether the governor, contrary to the advice given by the Council of Ministers, can and should accord sanction for the prosecution of a chief minister for allegations of corruption. And this question is specifically framed in the context of the governor granting sanction for prosecution against the Karnataka chief minister in 2024. So, and the second question, related question is, should sanction not be based on investigation and strong material evidence at the stage of seeking sanction itself?
Yes, let me answer the second question first. Yes, sanction should be granted on the basis of material already there. As far as the first question is concerned, I think it's a gray area because no cabinet will advise the governor to grant sanction to prosecute its own chief minister. And therefore, that would be one of the situations where the governor would have to apply his or her independent mind. And that is so in the interest of good governance, proper governance, constitutional governance. Because there is no presumption in our constitutional scheme that anyone is a saint. Therefore, this system of checks and balances, and if it has to operate logically, then in a situation like this, the governor can't be bound by the aid and advice of his council of ministers.
Right. And we just got one more question, which is, when states are being paralyzed and their freedom to function is being scuttled, as in the case of appointment of vice chancellors, then what can be expected from the Supreme Court of India in these situations?
Well, recently, in the context of the row between Tamil Nadu, again, between the DMK government and Governor Ravi on withholding assent of bills, the Supreme Court has told them to get their act together, otherwise it will decide. So here again, the Supreme Court, I think, in a properly constituted litigation, in a specific context, not an abstract PIL highlighting some instances and saying, please do something, the Supreme Court must ensure that the powers and autonomy of the state governments are respected, especially in the matter of state universities. It's the states which have created those universities, and to deprive the state government of its role in appointment of a vice chancellor is unacceptable. And the Supreme Court should look at this issue and set down the law very clearly.
On this point, even I had a question, which was, is there an argument to be made that we should do away with the tradition of having governors appointed as vice chancellors?
As chancellors.
And if so,
as
chancellors. And if so, is that something that should be addressed at a constitutional level rather than hoping for some decision by the Supreme Court confining the roles of governors as chancellors?
Well, that's an interesting thought. At a constitutional level, if it has to be addressed, it'll have to be done by an amendment saying the governor shall be governor simpliciter and will not have any extracurricular role, because this is so very clearly extracurricular. Yes, that's a good thought.
Now, another question is, what should be the criteria for picking candidates for governors? We know that the Constitution has minimum criteria, which are very minimal, but should the Constitution express more criteria?
I don't think that's going to help, because there are ways of getting around all stated criteria. Because if you say sufficiently educated, then honorary PhDs are not hard to come by. Correspondence MAs are not hard to come by. So therefore, ultimately, it has to be a sense of wisdom, maturity, and good sense that only people of some standing, and this, let me repeat, applies not just to politician governors, but also to bureaucrat governors and defense services governors. Because after all, you have former generals as governors, especially in insurgency hit northeastern states. Are they being chosen only for reasons of professional competence, or are they being chosen also because they seem to find favor? I'm saying this particularly in the context of the fact that we are noticing in recent years that even senior officers of the armed forces are going beyond their assigned role and expressing their patriotism, not just in terms of national patriotism, but in more partisan senses. And therefore, eminence must be understood in its true sense and not just in the sense of having held a particular rank.
Thank you for that. And now I'll pose the last question, which again moves slightly away from governor and more towards federalism. But since it has been asked, I'll ask it, which is, have states in a sense bartered away their federal rights by agreeing to the GST regime, their democratic right to tax the people who have elected them?
Well, that's a very, very complex question, and I don't feel I am competent enough to answer the question, because taxation is not my field of either interest or specialization. And I must make an honest confession that though I'm supposed to be an economics graduate from St. Stephen's College, I have no interest in economics to the extent that I don't take interest in the union budget. I don't read or understand the budget speech in detail. So at this point, I think I must throw my hands up and say, sorry, I passed this question.
On the next occasion, maybe the organizers of Anekdhara can answer the question that they have posed.
That's right. I'm sure some of them, since there are so many distinguished civil servants as part of this group, I'm sure one of them has administered GST in their respective states.
Thank you, sir. Those are all the questions. Thank you for covering so much ground.
Thank you. Thank you all for your patience and for hearing me out. It's been wonderful to be part of this
Thank you very much.
gathering of very distinguished people, many of whom I understand are former civil servants, government servants who've been given the best years of their life to public service. My salute to all of you for having chosen public service against lucrative private employment. And let's all hope together that our constitution endures for the next 75 years also. Jai Hind.
Yeah, thank you very much, sir. It's been really very helpful on a Republic Day to learn these things and gives us a lot of food for thought, and to understand that it's not just a recent thing. The decay of the institution, as you pointed out, right from 1958. But now it seems, as the questions also indicate, it seems like a very fast downward slide of the institution, and which is what prompted this topic. And we couldn't have had a better person than you to speak on it. Thank you very much for agreeing to be with us on this webinar. And Vikram, thank you for moderating this and handling the questions. Thank you very much. I just wanted to make the announcement, every last Sunday of the month, we have this webinar at this time. And we were actually looking at changing today's because of the Republic Day, but it turned out to be an ideal way, as I said, to celebrate Republic Day. Thank you again for joining, and thank you, sir, for giving us.
Thank you all again.
Thank you. Yeah.
Thank you.
Thank you.
Live stream closed.